In this lesson, we're going to talk about the concept of mutual mistake in relation to contract law. So we're moving on to what is known as the second type of mistake. The previous type of mistake is, of course, common mistake. And we noted that common mistake can exist in various different forms, noting, for example, that mistake as to quality is representative of quite a weak form of of common mistake, sorry, should I say. But then you also have mistake as to the existence of subject matter, as well as mistake as to the true owner of the subject matter, both of which are far stronger concepts of common mistake. Mutual mistake is a different type of principle that exists within contract law. We'll explain in this lesson what mutual mistake is, as well as how it operates at the common law with some case studies and some case examples. So, mutual mistake is very similar to that of common mistake. Both parties have made a mistake as to the terms of the contract or potentially its subject matter. So that's another point that we need to make. The key difference here is, though, that with mutual mistake, when it comes to mutual mistake, unlike that of common mistake, the parties have made different mistakes, okay? So previously, when we looked at common mistake, they both had made the same mistake. So the example of making a contract about a subject matter that didn't exist. They're both making a contract on the basis of a subject matter, and they're both mistaken as to the existence of that subject matter. That is what we mean by common mistake. But in cases of mutual mistakes, there are two different mistakes, at least two different mistakes. And when we see that, we say that the parties are at, quote, cross purposes. And so when they're at cross purposes, we get mutual mistake. Let's illustrate this with some case law, okay? So the 1864 case of Raffles and Rittelhouse, which is another word that I am unable to pronounce, is a case which involved the delivery of cotton on a ship. The ship itself was called the Peerless, and the contract said that it would be delivered on this ship and it will be arriving out of Bombay, but it did not specify the month that it was going to arrive. Especially in the 1800s, the mid-1800s, it was probably unlikely to actually have a good understanding of when the ship was going to arrive, given that the journeys of that nature in that time period took probably a very long time, an inordinate amount of time. Unfortunately, for the people who contracted in this particular agreement, there were in fact two different ships with the same name that were both arriving out of Bombay, and one was arriving in the month of October, the other was arriving in the month of December. So unfortunately, there were two peerlesses that were arriving out of Bombay, and one was arriving in the month of October, one arrived in the month of December. So two ships, same name, same place, roughly the same time. Okay, when it comes to shipping and all this kind of thing, the difference of 2 or 3 months is not really that huge, especially in the 1860s, as I've mentioned. So, quite ironic and quite difficult to understand. Both the claimant and the defendant had different views about which ship the contract was in fact referring to. The claimant believed that it was a contract for cotton that was arriving in December. The defendants believed it was for cotton that was arriving in October. Oh yeah, I forgot to add as well that both the same ship of two different ships of the same name that were both arriving out of the same place in roughly the same time period and carrying the same cargo. So there was also that problem. It would have been easily solved if one was carrying something other than cotton, because then you come to the conclusion, it's the one that's carrying cotton that is the ship that we're referring to, because our contract is for the delivery of cotton on a ship. Unfortunately, they were both delivering cotton, so unfortunate there. So litigation was brought on the basis of a breach of contract, because there was a disagreement as to which ship, in fact, belonged to the agreement, which ship actually was the one that the contract was referring to. The courts were tasked with the job of identifying the operationalization of mutual mistake, and they concluded that if, on reading a contract, a neutral third party would be able to find a common intention as to which ship the contract was referring to, this would render that contract valid and binding. So if you take a neutral third party and you get them to read the contract, and you can see, and they can come to a conclusion as to what the contract is referring to, then this common intention would therefore render that contract binding, and whoever was wrong in that instance, in fact, would have to pay damages out of by way of breach, because they have breached that contractual arrangement. However, when reading these contractual terms, there was in fact no indication whatsoever as to which ship was being referred to, okay? Because they were both the same name, they both arriving out of Bombay, and it wasn't specified necessarily which month it was going to arrive. So the only distinguishing feature of these two ships, essentially, for our purposes, was which month they were going to arrive at, because they was the same name, they were going from the same place, and they had the same cargo. So the only difference between these two ships was that one arrived in October and one arrived in December. But because the contract doesn't specify which ship, it doesn't specify the month that it was going to arrive, it doesn't specify that, then the distinguishing feature, the only distinguishing feature, is not part of the contract. So there is no distinguishing feature in the contract. There is no indication as to which ship the contract was referring to, and so there was therefore a mutual mistake, and the doctrine of mutual mistake was therefore valid, and the contract was therefore void. Another case is the case of Scriven Brothers and Co. versus Hindley and Co. from 1913. This principle that was established in the previous case relating to the ship was upheld in this case. The defendants in this case had made bids at an auction. It was for two different lots, with the belief that they were bidding for hemp in both cases. However, it later transpired that one was hemp and the other was tow. As such, one was significantly more valuable than the other. Again, the court would have to consider whether or not a reasonable neutral third party would be able to make a determination in the contract as to whether or not they had brought hemp or tow, whether or not a distinction could be made here that is able to essentially delineate which lot was which. They considered that in both lots they contained they both contained the same label, SL, which was a mark the purchasers believed indicated the presence of hemp. The courts concluded that a third party therefore would be unable to determine the difference between these two different lots and these two specifically within the contract, and so just like in the previous case, the contract was void on the basis of mutual mistake.